Hasseltvogt.
My lady, in other words, before the short adjournment, I said that I would give the reference in the Law Commission's consultation report to the possibility of lawyers committing criminal offences in answer to a question by my Lord Reid. It is actually in the Authorities Volume 1, and it's at MS 498 and 499, where there's a discussion, and I don't think I need to go into any detail, about the hazards of negotiating, facilitating and advising on surrogacy arrangements, and the possibility that inadvertently a criminal offence may be committed by a family law in the jurisdiction. This is 9132. Because in fact, although you would certainly inadvertently commit a criminal offence if you negotiated a commercial surrogacy agreement in this country, it also appears that you would be guilty or might be guilty of a criminal offence by negotiating a surrogacy agreement abroad. And I was right when I said before the short adjournment that if it was a Californian attorney negotiating in California, of course that would not be the position. So if one then goes,
which paragraph are you referring to?
The relevant paragraph is 9.132, so it's the bottom of 498.
Yes, thank you.
And if I can take the court briefly back to the Surrogacy Arrangements Act 1985, which is behind tab 7 at the same bundle, MS 233. It provides, under the heading Negotiating Surrogacy Arrangements on a Commercial Basis, no person shall on a commercial basis do any of the following acts in the United Kingdom, and that includes initiating any negotiations, taking part in any negotiations, offering or agreeing to negotiate, compiling any information with a view to its use in making or negotiating, and no person shall in the United Kingdom knowingly cause another to do any of those acts on a commercial basis, and then goes on to say they'd be guilty of a criminal offence, subject to those two exceptions I've already indicated to the court too. So that we submit makes good the point that I was indicating. The objections to commercial surrogacy are, we submit, understandable and principled, and we set them out in our printed case at MS 93. It's an attachment to our printed case, and clearly I don't propose to go through all of it, but it emphasises that the commodification of the process of giving birth is the same wherever it takes place. And what is sometimes described emotionally and perhaps even in inflammatory language as the sale of a child is for many wholly unacceptable. And there can be little doubt, my lady, my lords, that surrogacy can all too often involve the exploitation of women, often of considerably less bargaining power in other countries. And that's the case in the United Kingdom, even though here the potential for exploitation was probably less. The irony is that there is a difference between UK and overseas arrangements. The courts are likely to know much less about the satisfactoriness or otherwise of the system in another country than they are here. And yet the result of the Court of Appeal's decision is that a commercial agreement entered into here, albeit that it would be unlawful, would still be unlawful. But if entered in California or Ukraine or elsewhere, so the argument goes that there is no difficulty. And we say that's a very unsatisfactory response. Now, the evidence indicates that the United States is a popular destination, but that surrogacy there, and in particular in California, is the most expensive. Now, clearly, not all, or even anything other than a very small minority of those seeking to enter into surrogacy arrangements abroad will have a large award of damages, either generally or more specifically to enable them to seek an overseas surrogacy arrangement in other popular destinations, and I indicated for the short adjournment, Ukraine, Georgia. And there's probably a greater risk of unsatisfactory commercial situations prevailing. But even in California, all things are not entirely satisfactory. And I wonder if I could take the court to Authorities Volume 2, tab 28. This is MS 1181, which is the report of the Special Rapporteur to the United Nations, which includes a study on surrogacy and the sale of children. If we go to 1183 under the heading Study on Surrogacy and the Sale of Children, paragraph 8 on that page, the present study addresses a further such gap regarding the sale of children in the context of surrogacy. It's a logical follow-up to the study on illegal adoptions, wherein the Special Rapporteur already noted that international regulatory vacuum that persists in relation to international commercial surrogacy arrangement leaves children born through this method vulnerable to breaches of their rights, and the practice often amounts to the sale of their children. The Committee on the Rights of the Child has consistently expressed similar concerns that surrogacy could lead or amount to the sale of children. If we go over...
Sorry, where do you find that?
So that is at paragraph 8 under the heading Study on Surrogacy and Sale of Children. It's on 1183.
Oh, 1183, sorry. Thank you.
And then over the page on 1184, there's a passage talking about the position of human rights experts and the problem rooted in patriarchal conservatism. But perhaps particular relevant is under the heading Urgent Concerns, paragraph 3, still 1184. Surrogacy as a reproductive practice is on the rise. Indeed, as inter-country adoptions have fallen in number, increasingly become subject to international standards, the numbers of international surrogacy arrangements have rapidly increased in the absence of international standards. Therefore, surrogacy, like inter-country adoption in the 1980s and 90s, has emerged as an area of concern where a demand-driven system may endanger the rights of children. There's also an unease and concern the practice of engaging surrogates in states with emerging economies to bear children from more wealthy intending parents from other states has dimensions similar to those discussed in the reports on inter-country adoption. Then at paragraph 15, over the page at 1184, national laws governing surrogacy vary across a spectrum from prohibitionist to permissive. This variation occurs across national boundaries and sometimes within national boundaries. The surrogacy is sometimes regulated primarily by local law, i.e. in Australia, Mexico and United States. The most prohibitionist jurisdictions such as France and Germany ban all forms of surrogacy, including commercial and altruistic and traditional and gestational. Most jurisdictions with laws governing surrogacy prohibit commercial, for-profit or compensated surrogacy, and goes on to deal with the other areas and finishes, however, Georgia, the Russian Federation and Ukraine, this is the last sentence, and some states in the United States have for a sustained period of time chosen to remain centres for international surrogacy arrangements. Can I take the court to 1187 at paragraph 24 of the report? Surrogacy, in particular commercial surrogacy, often involves abusive practices. Furthermore, it involves direct challenges to the legitimacy of human rights norms, as some of the existing legal regimes for surrogacy purport to legalise practices that violate the international prohibition on sale of children, as well as other human rights norms. Moreover, many of the arguments provided in support of these legal regimes for commercial surrogacy could, if accepted, legitimate or legitimise perhaps practices in other fields such as adoption that are considered illicit. Thus, if this type of governing legal regime becomes accepted, whether as international or national law or through recognition principles, it would undermine established human rights norms and practices. Now, there's quite a lot of evidence from the American Bar Association contained in this report from the Special Rapporteur, but not all of it is encouraging. Under page 1189, under the heading Abusive Practices in Surrogacy Systems, paragraph 29, abusive practices in the context of surrogacy are well documented. Examples include sex offenders from Australia and Israel employing surrogate mothers from India and Thailand, a wealthy Japanese man employing 11 surrogate mothers, leading to births of 16 infants in Thailand and India, the abandonment of a surrogacy-born infant with a disability in Thailand. And then paragraph 30, many of these abuses occur in unregulated contexts, often in cases involving intended parents from Western countries, employing not-for-profit intermediaries to contract with vulnerable surrogate mothers in developing countries. However, abusive practices also occur in purportedly well-regulated commercial surrogacy jurisdictions. For example, 2 prominent surrogacy attorneys were criminally convicted in a baby-selling ring in California, a centre for international surrogacy arrangements. According to governmental authorities, a prominent surrogacy attorney admitted that she and her conspiracies used gestational carriers to create an inventory of unborn babies that would sell for over $100,000 each. The convicted told the local media that as to abusive practice, she was the tip of the iceberg of a corrupt billion-dollar industry. I don't think I need to go on except to say that there's clearly great cause for concern about commercial surrogacy, even in places like California, where it's quite well established.
Lord Folkes, one isn't surprised to read that sort of concern, but is there a difficulty about the judge's findings in relation to surrogacy in California? Because he speaks highly of it. And I just wonder whether you are entitled to, as it were, come round the corner and visit us with evidence which might sow doubts in our mind about the quality of the system there.
Well, the judge decided on these particular facts that it was appropriate to go. I don't think he conducted a kind of in-depth analysis of the Californian surrogacy market. And of course, this is all prospective, so we don't know what the agreement would have been, might be made in the future with what agency and how satisfactory. So that, although I understand the point that my Lord is putting to me, we nevertheless say we're entitled to say, when we're looking at the broad picture of commercial surrogacy, we are entitled not to say that there are not perfectly lawful and legitimate in California and satisfactory arrangements in California. It's not all of a piece, or not necessarily all of a piece. So if we're asking judges in the future to decide it's appropriate toward commercial surrogacy, they will have to make judgments as to the satisfactory arrangements in the future, which might or might not transpire.
Very well.
I suppose it could also be said, but disavow this if you wish, that this was all in the context of explaining why the claimant wanted to go to California, perfectly understandable, and in the context of a judgment in which he said she couldn't have the damages to enable her to do so.
Indeed, of course, yes. And so that he decided he was bound by the Court of Appeal, an inhibition that the Court of Appeal, in this case, did not feel, for reasons that are altogether clear. Can I take the court now to our core volume? And while I'm dealing with the arguments against commercial surrogacy, I just wanted to refer to a passage at MS 96, which is our case, the attachment, paragraph 8. The special rapporteur, again, made reference to the case of Cook and Harding, where a surrogate mother attempted to bring a petition for certiorari before the United States Supreme Court, which refused to hear the petition. This case involved a surrogate mother who refused to undergo a reduction abortion when she was found to be pregnant with triplets. The petition for a writ of certiorari was supported by a motion to file and brief by 10 feminist academics. As amici curiae, they summarise their argument as follows, and there is a rather vivid description on the opposite face of why surrogacy is the commodification of women and the commodification of children. Even references to Margaret Atwood's Handmaid's Tale. And so there is a very strong argument against commercial surrogacy for all sorts of standpoints, and sympathetic, profoundly sympathetic, though one is to those who seek surrogacy arrangements of a commercial nature for the reasons that the claimant gave in this particular case. We submit there are real problems and there should be real objections as to a court actually awarding damages on that basis. The position around the world in relation to surrogacy, we've attempted to assist the court by providing a summary of it, firstly in our printed case and also in slightly more detail in an attachment. Our printed case really shows that there's a lack of a consensus generally. We deal with it at page MS 73. in short, in the United States of America, there is a variation from state to state. Some legislators do nothing. Sometimes there's an outright prohibition. And obviously the most liberal include California, New Hampshire, Arkansas, and Illinois, whereas all sort of contracts of any sort are outlawed in Michigan and New York. Variations in Australia and in New Zealand, in Canada. I told the court about the position in India. And then paragraph 56, we deal with the question of the European Union. Some countries are it's permitted, but they're specifically prohibited commercial surrogacy agreements in quite a lot of countries. There's no prohibition of commercial surrogacy in some other countries, and a general prohibition on all forms of surrogacy in other countries, including France, Germany, Italy, Malta, Portugal, and Spain. And I indicated that the European Court of Human Rights had not, as it were, intervened in this particular area. But what we can say is that none of the major common law jurisdictions permit commercial surrogacy, and in fact specifically prohibit it. And
so you're saying California isn't a common law jurisdiction?
The other Californian, the other jurisdictions apart from...
In a way, you could be right about that.
Yes, that is possibly right. In any event, certainly the common law jurisdictions to which we normally refer, such as Canada, Australia, New Zealand, etc. So we say there are good grounds for the outlaw, apart from the fact there are specific statutory provisions to that effect. The question of parental orders. There are a number of cases in the bundle which deal with them. In particular, a decision of Mr. Justice Leahy, which was an adoption application before, in fact, parental orders came in. I think it probably isn't necessary for me to go to these cases, but I can just give you the reference if it assists, which is MS 613, Appeal Authorities Bundle 2, Tab 4. Then there are two useful decisions of Mr. Justice Headley, who has some helpful observations about surrogacy generally. There's one called In Re L, which is MS 633, Authorities Bundle 2, Tab 6, and another one, Re X, Authorities Bundle 1, Tab 13, MS 367, and finally a decision, Re C, upon which some reliance is placed by the Court of Appeal, Mrs. Justice Tice, who I know as an advocate was involved in surrogacy, and clearly one takes considerable note of what she says in this particular area. That's MS 362, Authorities Bundle 1, Tab 12. But in a sense, although the judges involved in these decisions have slightly different approaches, the burden of it all is this is a court being presented with a fait accompli, a child who is before them, a settled situation almost certainly, which is why they are seeking the blessing of the court to get a parental order. The overwhelming interest of the child is the welfare of that child. And we submit that the fact that the court is concerned primarily with the welfare of the child and its security by giving a welfare order does not undermine our argument about commercial surrogacy. Now, it's true that expenses has been, as it were, looked at in a reasonably relaxed way by the courts. I think perhaps that's the best way I can put it.
It's one of the greatest euphemisms known to jurisprudence, I would have said.
Well, but it does not in any way undermine our essential submission in this case, but we do acknowledge the fact that the court is concerned with the child as one would expect it to be above all else. So can I, really by way of conclusion, come to one of the only academic articles which has been written about this particular case, which we can find in Authorities Volume 2, MS 1110, tab 24. It's an article in the Law Quarterly Review by Algrani and Purshouse, about specifically this case, but obviously commenting on surrogacy and in particular the decision in Brady to which I've referred. And if I could take the court to page number 1111, that's the second page of the article, we can see about 4 paragraphs down, the authors say this note will focus on whether the Court of Appeal was correct to award damages for an overseas commercial surrogacy arrangement. First, it is necessary to give a brief overview of the law of surrogacy in order to appreciate how this decision allowed the ban on commercial surrogacy to be subverted. Domestically, the law was developed in a haphazard fashion and goes on to deal with the various provisions to which I've already referred. Can I go over the page to page 3 and the third paragraph down? Justice McComb is correct that the illegality defence does not apply to Ms. X. The 1985 Act does not have extraterritorial effect, and the provisions prohibiting commercial surrogacy do not catch the surrogate and intended parents. There are good reasons for this. Whatever one thinks of commercial surrogacy, it would be undesirable to throw a newborn child's intended parents and the surrogate mother in jail and place the child in care when the intended parents are perfectly capable of looking after it. Yet while Ms. X would not act illegally by taking part in a commercial surrogacy arrangement in California, such an arrangement would be illegal if it were performed in this country, even if it were to be other parties and not the claimant herself who would break the law. The Court of Appeal acknowledged that domestic law prohibits commercial surrogacy businesses, quote, in circumstances in which we have no standards set for their operation, no licensing arrangements, and no regulatory policing of day-to-day operation. The reason why there are no such standards, licensing arrangements, and regulatory policing of commercial agencies in the UK is not because it is beyond our ability to make them, but because Parliament sees such profit-making practices as undesirable, whether regulated or otherwise. Altruistic surrogacy is not contrary to public policy, but binding contracts and the involvement of profit-making third parties is something Parliament has legislated against. Surrogacy arrangements are not enforceable domestically because English law allows the surrogate to change her mind, and if the child's welfare interests demand it keep the child, law can accept that the intended parent should not be criminalised without wishing to encourage commercial surrogacy. The argument, of course, before the Court of Appeal, which is referred to at the foot of the page, is that Patel and Mertzer provided a fresh opportunity to examine public policy. And the authors, however, consider, I'm going over the page to 113, Patel is undoubtedly a landmark case, but it is arguable that it does not justify reconsideration of Brady, as the defence of illegality was not a hurdle in that case. Neither Ms. X nor Ms. Brady would have acted illegally at that time that Brady was decided. Instead, Brady was concerned with the separate issue of whether or not awarding damages was contrary to public policy. Patel is not necessarily relevant to the latter question. With respect to the Court of Appeal, it went beyond the scope of Patel in departing from the binding authority of Brady on this occasion. I haven't wearied the court with Young and Bristol aeroplane on the basis that that ship has rather sailed, but nevertheless, we do submit that it's surprising that the Court of Appeal didn't explain why they felt able to depart from this, except by reference to Patel and Mertzer, and we submit that's an unsound basis on which to do so.
There's a clear distinction, is there not, between the illegality defence, which is sometimes known as extirpi causa for very good reasons, and public policy objections to allowing a particular head of damages. And I'm thinking of a case like McFarlane and Tayside, where there was no question of illegality, but nevertheless the House of Lords held it was contrary to public policy to enable somebody to get damages for the upbringing of a healthy child. And all that line of cases, they're all public policy, there's no illegality involved anywhere. And at the other end of the spectrum, there's Gray, where, of course, there was an illegality involved because the victim of the tort had then gone on to commit heinous crimes. So,
well, my lady's absolutely right, if I respectfully say so, refer to McFarlane, because further down the page...
You were about to get there, weren't you? Yes, yes. I'm doing it to you all the time, aren't I, Lord Fawkes? I'm sorry.
No,
yes.
halfway down the page, times may have changed since 2001 in many respects, but not in the ways that are particularly pertinent to this issue of whether Brady was correctly decided. First, Re C, that's the case I referred to about parental orders, is not the landmark decision that the Court of Appeal portrays it to be. Payments in excess of reasonable expenses were approved at the time of Brady. If English law takes a flexible approach to surrogacy in approving payments, it is because such restrictions are meaningless when faced with an existing child whose lifelong welfare requires parental responsibility to transfer to the intended parents. This does not indicate that the law supports commercial surrogacy as much as it supports the child's welfare interests. And secondly, transformations in societal stances towards unmarried and gay couples and single parents do not indicate that attitudes towards commercial surrogacy have changed. In fact, a recent report from Surrogacy UK, which is in the bundle, based upon responses by surrogates and intended parents, opposed a commercial model. So illegality was therefore a red herring. Instead, the crux of the dispute is whether damages should be awarded. Assessment of damages involves a value judgment. For example, in Pritchard, the Court of Appeal refused on grounds of public policy to award the claimant costs associated with divorce that resulted from his personal injury. As noted earlier, there are convincing reasons for not awarding the costs of Californian surrogacy. In this case, doing so undermined English law's policy of discouraging commercial surrogacy. Finally, it's noteworthy that the Court of Appeal handed down the judgment in XX only 2 days after its decision in ARB. This breach of contract followed McFarlane in declaring that the costs of raising an unwanted healthy child born as a result of the defendant's wrongdoing are irrecoverable. In Rees, Lord Bingham believed the policy behind this was a sense that to award potentially very large sums of damages to the parents of a normal and healthy child against a National Health Service, always in need of funds to meet pressing demands, would rightly offend the community's sense of how public policy resources should be allocated. We might question an approach that transfers scarce NHS funds to commercial surrogacy arrangements in California so that a child can be created, but balks at providing the existing children born as a result of medical negligence with a decent quality of life. The natalist leanings of English negligence law appear to respect people's wishes to have children, but not their desire to avoid parenthood.
Is the Pritchard case worth looking at?
Is the Pritchard case, I'm not sure that it helps very much,
Very well.
but we will certainly provide it to the court if it was helpful. I'll come back to it and reply, perhaps, if I may. So, concluding, I think, ahead of my time, I would submit this on behalf of the hospital. The public policy is clear, we submit. There should be no damages for commercial surrogacy wherever it takes place. Apart from anything else, the integrity of the law, Patel and Merzer demands that, and it would make little sense for a court to, in effect, sanction something unlawful here, simply because it takes place outside the scope of this court's or any legislative body's jurisdiction. As to the question of altruistic surrogacy, we have made our submissions. I made almost at the outset in respect of that. We essentially say that that is a step too far, as was suggested by the Court of Appeal in Brady for the reasons that we give. It doesn't have precisely the same objections as our submissions in relation to commercial surrogacy, but we do say that the unique nature of surrogacy as a head of damage puts it in a different category to all the other conventional heads of damage which judges are often asked to undertake. Learned friends say, well, judges often have to listen to 10 expert witnesses in complex medical negligence cases. So be it, and judges have to resolve issues. But the issue in those cases will often be whether there's a departure from an appropriate standard of care, what would have happened absent the negligence and the like. The evidence may be complex, but the issue they have to decide is essentially one to which judges, we would respectfully submit, are entirely well suited. This is a rather different matter for the reasons that we have already developed in argument and have emerged during the course of questions from your lordships, involving all these third parties, involving very difficult questions of the future, value judgments and the like. And we submit that the right way to solve this is an award, a generous award of pain, suffering and loss of immunity, which allows claimants to pursue what remedy they feel is appropriate for them as a result of infertility, just as somebody who was not the victim of a tort would decide what, if any, course they wanted to take. So in our submission.
So just, sorry, following on from that, do you consider that the award of £160,000 for pain, suffering and loss of immunity was about right or generous or mean?
Characterised as mean. It's certainly more or less the top level, but we do concede in our printed case that if we succeed in our claim and the court decides that neither altruistic nor commercial surrogacy damages specifically for the cost are appropriate, then there would be an adjustment to the award for general damages for pain, suffering and loss of immunity. And we would invite the court, if the court were to decide, in agreeing with our submissions, that was the approach, that I would hope the parties would be able to agree an amended figure for pain, suffering and loss of immunity between ourselves, failing which, of course, we would have to come back to the court, perhaps with written submissions, but I can't imagine that that wouldn't be capable of resolution.
What would the yardstick for that extra calculation be?
Well, the yardstick would be this, because the original award by Sir Robert Nelson was on the basis of 2 children by an altruistic surrogacy. There was then an adjustment to the award, because on the Court of Appeals hypothesis, the claimant would be able to have 4 surrogacies. So now there was a necessarily corresponding adjustment downwards of the general damages to reflect that. If the court is with us, then clearly there will be an adjustment upwards to reflect the fact that although she could not recover the cost of surrogacies, whether altruistic or commercial, there should be a higher sum, so there was no deduction on the basis that she did actually have the children, so the infertility was not quite such an acute loss as it might otherwise have been.
And what would the yardstick for that extra calculation be?
Well, I mean, these are conventional sums, usually assessed by relation to judicial college guidelines or by similar awards. There aren't actually many similar awards, so that would be a question of looking at it and adding, say, 20,000 or something of that sort to that figure.
Thank you.
Thank you.
Thank you. Mr. Feeney?
My Lords, my ladies, I follow.
My lady, my lord, can I thank the court for the anonymity order which has been granted in this case, and could I indicate that the respondent sends her apologies. She's unwell today, but is hopefully following things through the remote feed.
Well, I very much hope that one of the advantages of our live streaming our proceedings is that your client will be able to watch what is going on. And I hope that she will not feel there is any disrespect intended if we treat matters in as smiling a way as we possibly can, because these are difficult and sensitive topics, and we think that is the best way to try and approach them. Keep the temperature down, in other words.
Thank you, my lady. In responding to my learned friend, if I could invite the court's attention to MS 103, which is the start of the respondent's case. And I'd just like to use that to indicate the roadmap for my submissions, which will follow the structure, but I should stress not the content, of the respondent's case. So the additional points that we wish to make, the intention is to follow that structure, albeit I should note that under 3 Bridie, I will only touch briefly on it under that 3rd heading, but intend to expand on it more fully under heading 6, and then again in dealing at 10 for waiting for Parliament. It may, however, assist if I could make, and I can use the introduction heading for this, 5 key introductory points. The first is, and this is really to pick up the point that my Lord Wilson was making, this is a case that was decided and surrogacy was awarded here simply on the evidence as found by the trial judge in this case. There was extensive evidence received here about the reality of surrogacy for this claimant, for the reality of what that meant and why she wished to have it. But the first instant determination was not making any wider determination. It wasn't saying that somehow in all infertility cases there is an absolute right to claim damages for surrogacy here or in California. It was stressed by the Court of Appeal, Lord Justice McComb, that the reasonableness will have to be proved in every case. And that's at paragraph 96 MS 182. We don't need to turn it up. But in another case, the defendant can clearly challenge what's being contended for and can raise some of the points that have been raised in material which has been put before the court for the first time in this appeal. It's completely open to defendants to do that. All the judge was finding here was in the unusual facts of this case, in a claimant who had very restrictive fertility options. She had again, and really one needs to apologise as my lady has done to Miss X, but in our language, she's only 2 rolls of the dice with her own genetic material. And she had her own particular familial circumstances and her own particular psychological vulnerabilities, which meant in this particular case, it was a reasonable decision that was taken. And that reasonableness has not been challenged on any appeal. What we submit here is that the same test as is applied in respect of all other heads of damage should be applied here. That all other categories of torturous victims do not face such a bar on a reasonable medical expenses claim or a reasonable claim. And we assert, just as tortious victims here, those who suffer infertility, have no absolute right to recovery of surrogacy, similarly and conversely, there should be no absolute bar. And fundamentally, we would submit that's what is wrong with this, the key thing that's wrong with the submissions of the defendant. So the second introductory point we would make is this, and it's really to address the point that was made earlier about what recompense is here. And as nearly as possible, the recompense here is tied to her wish to find a family, as set out in Lady Justice King's judgment, with children with as close a genetic connection as medical science can currently obtain. So children, 2 children hopefully with a full genetic connection, and secondly, 2 children with a genetic connection to her partner. And what one's doing is to pick up, I think it was my Lord Carnwath and my Lord Kerr's point, is that what the judge was doing was having, as in every other case of assessment of damages, make an assessment for the future. And that entails assessing the evidence before the court then in respect of what people wish in the future. And that does entail, my learned friend Lord Fox has talked, sometimes you're talking about what the house will be in the future for someone, or what gratuitous care will be needed, whether the parents will stay involved in care of a disabled child. And all of those are considerations which, contrary to the respondent's submissions, we say Queen's Bench Division judges are well able to make. And it involves assessing the credibility of the claimant in front of the court, and the credibility of the scientific evidence that underpins that. And the Queen's Bench Division has an advantage here which the Family Division does not have. They're able to make the assessment in advance, whereas within the Family Division in respect of surrogacy, often the assessment is made when the deal has already been done. If I could then turn to my third introductory point.
Well, that arguably makes it easier for the Family Division judges than it does for the Queen's Bench Division judges.
Maybe it's an unusual example of when their life is easier.
Yes.
My third point ties to my Lady Hill's question about what is the appropriate framework to apply here. And we say that ultimately there's different routes and paths to here. But ultimately, there's 2 routes on offer. Or sorry, 2 outcomes on offer. There's more routes on offer, sorry, I apologise. The respondent's route, what we submit, is that the court here should work within the framework of Patel, should work within the framework of legality, because that is what this is about. And as it has been said in the Family Division and elsewhere, there are moral differences, there are ethical differences about this issue in our society. But what the assessment we say here needs to be grounded on the fundamental question of what is legal or not. And because we assert that illegality is at the heart of this, we therefore say on that route 1, if you like, that Patel applies. Route 2 may be to say, this is public policy. But what does that mean? And I'll come to a potential analysis for that in a moment. But what we would say, what Patel was about, wasn't simply illegality. At its heart, it was addressing the need for consistency within the legal framework and consistency between the criminal courts, the Queen's Bench Division, and here the Family Division. And it was consistency and the assessment of public policy that was at the heart of those considerations within the judgment in Patel. And it's for that reason that if that one goes down route 2, one then goes back to where we would start, which is looking at what Patel defined as the trio of considerations, and that is the test. And I'm sure the court has this, but the relevant MS number and paragraph for that disposal in Patel is MS 317, and it's in the speech of Lord Toulson, noting that the essential rationale of the illegality doctrine is it would be contrary to the public interest to enforce a claim if to do so would be harmful to the integrity of the legal system or possibly certain aspects of public morality, the boundaries of which have never been made entirely clear and which do not arise for consideration in this case. In assessing whether the public interest would be harmed in that way, it is necessary, A, to consider the underlying purpose of the prohibition which has been transgressed and whether that purpose will be enhanced by denial of the claim. B, to consider any other relevant public policy in which the denial of the claim may have an impact. And C, to consider whether the denial of the claim would be a proportionate response to the illegality, bearing in mind that punishment is a matter for the criminal courts. And notes then that within that framework various factors may be relevant. And the final sentence, the public interest is best served by a principled and transparent assessment of the considerations identified, rather than by the application of a formal approach capable of producing results which may appear arbitrary, unjust, or disproportionate. So what we submit is whether the court agrees with our assessment that this is a pure illegality or tainted by illegality case, that is the test that should be applied. But alternatively, we say if you accept the appellant's argument that this is a public policy determination, that nevertheless you end up in the same endpoint and the same considerations. Because the alternative is the second option. So we have one option, which is the trio of considerations. The second option is the trust absolute position on the jurisprudence, that no, there's an absolute bar. That is what they are asserting. There's an absolute position on surrogacy, and there's an absolute bar. But we would submit that that cannot be the case because it should be subject to a proportionality assessment. And I'll return to that within the detail of our submission. But that leads on to my fourth introductory point, because we say whatever the detail of the route the court takes here, one must end in a proportionality assessment. And we submit that the Court of Appeal's conclusion that the use of the illegality bar on the facts here would be disproportionate, would be overkill, was a wholly reasonable conclusion for them to reach on the facts of this case. To date, no intended parent in the United Kingdom has been barred or is likely to be barred from undertaking Californian surrogacy. If the purported public policy contended for by the trust exists, which we deny, it is not one which in fact operates in practice. Hence, it has been correctly defined in the speech of Lord Justice McComb as a notional public policy. And we would say that the court should operate in the real world, and to repeat the submission we made in the Court of Appeal, that Miss X should not be the sole martyr to that notional public policy. So we would say that if the court is with us on my fourth point, that should result in the appeal being dismissed. The final introductory point is this, is to deal with the polycentric problem, the Parliament contention made by the appellants. We are not asking for a change in the law on for-profit surrogacy in this country. We are not asking for any change in the law. The Re-Z case, which you may have seen, where a remedial order was granted because of incompatibility with the European Convention, is a far more radical and constitutional case than this. Because what we say is that the Court of Appeal's determination here is a vindication of parliamentary intent, is a vindication of the rule of law in respect of applying standard restorative damages principles to the facts of this case. The court wasn't addressing an issue here that was for Parliament to resolve. It was a simple problem, which it is the court's job to resolve, which is what law of damages should apply given what Parliament has legislated for since 2001, and given the changes in our law and society since then. And what we would submit is the Court of Appeal undertook a layered consideration. We submit appropriately concluded that they were not bound to conclude that there was a purpose being transcended here, or they're bound by Bridie because of the changes in the law since 2001. We submit it's not a polycentric problem, the case for the court or for Miss X. It's a simple problem of why should Miss X and others like her have been rendered infertile as a result of tortious injury? Why should they be marooned on a jurisprudential island stuck 2 decades in the past? Why should she not recover for a central loss governed by the same tort rules as anyone else? And we submit that the answers today, given the current legal framework and wider legal framework and societal framework, is that she shouldn't be marooned and she should recover here. Whether because we are right that there's been no purpose transcended, or alternatively, because if you undertake the tree of considerations and you do consider that under one there is a purpose that's an issue here, we would say the weighting process and the proportionality process all heads one way, and the Court of Appeal were right in saying it would be overkill here, and that it would vindicate the tort's restorative principles by enabling her to become the mum she always wanted to be, and that there's nothing unlawful in that, and there's nothing unreasonable or contrary to any notion of public policy in that. Could I turn then very briefly to 2 and 3 in my headings, which are facts and Bridie. Maybe just to pick up one referencing point, this morning there was a request in respect of the reference in the paragraph to the first instance judgment and the determinations about family. We don't necessarily need to turn it up, but if I could give the references, that might be the easiest. I have 3 references in respect of the findings in respect of the family by Nelson, which is 194 paragraph 7, 199 paragraph 33, and 203, MS 203, paragraph 51, and that deals with the underlying findings, and I won't take the court's time with that now.
The last one was para
51.
Okay.
Could I therefore look instead, very briefly, at the facts through the prism of 2 cases? And I want to identify under my heading 2, 5 similarities with the case of Re-C, and under my heading 3, 5 differences with the case of Bridie. And to that end, could I invite the court to turn in the Authorities Volume 1 to the Re-C case, and to paragraph 19 within it, which is MS 365. The court, in our written case, has seen reference to this in the detail of it. It's a case in which Mrs. Justice Thice granted a parental order in respect of applicants who had entered into a surrogacy arrangement with costs involving about $95,000 and had obtained approval under Section 54 for a parental order. And at paragraph 19, I won't read the paragraph, but if the court has that paragraph, if I pause a moment. If I just identify the five similarities from Miss X, using the language of Re C, Miss X is proposing to act in good faith. Secondly, she is proposing to comply with the requirements in the US. Thirdly, she's proposing to comply with the requirements in the UK. Fourthly, there's no moral taint in the applicant. There's no reason to suspect that Miss X is someone who would exploit people and so forth. And there's no reason to suspect that she's someone that family court would not grant a parental order to. And finally, the fifth point is that, again, here the evidence supports the contention that these would be much wanted children. So those are five similarities with Re C, and I'll return to the significance of the parental order cases in a moment. But if I may, and I think I'll only need to turn to one reference, which you've already seen in respect of Bridie, the five differences with the Bridie decision. The first point, which I'll return to under the purpose of the current legislation, is that Bridie was decided under a wholly different legal framework. Legislation now permits financial arrangements with third parties. That did not apply in 2001. But I'll return to the details of those systemic changes later. Secondly, as I've already noted, in Miss X cases, detailed and unchallenged evidence, including expert evidence about surrogacy and the nature of the Californian system, whereas in Bridie there was no evidence or limited evidence about the Californian system and no expert evidence in relation to it. Thirdly, the chance of success here is good, and that's the finding, whereas in Bridie there was a vanishingly small chance of success. And that determination alone decides the Bridie case, because there was less than 1% chance of this working. And it ties into the contrast that one has here, where all the medical evidence, both physical and psychiatric, supports Miss X in saying this is a reasonable and sensible choice for her. Whereas in the Bridie case, her own expert, Miss Bridie's own expert, Mr. Kraft, said it wasn't. He didn't think it was a sensible thing for her to do. And fourth difference here is that in this case with Miss X, there's an unusual psychological focus on her fertility. One of her central ambitions in life was to find a family, and she's had, since her negligently caused infertility, she's had a consistent focus on it. And it's had a significant psychological impact on her, such that she will no longer visit her sister, who's got 10 children. And one can see that difference in psychological focus from the fact that Miss X had her fertility and ultimately surrogacy in mind immediately. She delayed her cancer treatment. She risked her life in order to do that, versus in Bridie, Miss Bridie only looked to surrogacy about 25 years after the index events. The fifth point, this is where if I could return you to a passage that Lord Folkes referred to earlier, which is on MS 259. And this is Justice Ebsworth's first instance judgment. And you were taken to the middle paragraph. And if I could read, it's about halfway down, if the court has it, in both adoption proceedings and proceedings for a parental order, the court has that. Under Section 30 of the Human Fertilization and Embryology Act, the applicants must be husband and wife. On any view of our law, the claimant seeks an award of damages to acquire a child by methods which do not comply with the law, and then deals with it there. It's just to note, and I'll pick up on this later, that noting that really the seismic change that's taken place in respect of the surrogacy landscape is that Miss Bridie couldn't apply for surrogacy then, and in fact Miss X, if she'd been around under that law, would not have been able to apply for surrogacy. And I just note that to note the dramatic change.
Couldn't apply for surrogacy?
Because she wasn't married.
You mean a parental order?
Sorry, I apologise. Yes, she couldn't apply for a parental order.
Your fifth point is really part of your first point.
Yes. If I turn to the fourth heading, which is dealing with compensation for tortious wrongs, and I think in the main I've dealt with this within the written case and within the introduction. And so what we would submit is that we have with Miss X someone who's done remarkably well in managing her embarrassing condition, managed to keep her job and progress in it. And she now has a wholly different and much reduced life from the one that she and her partner reasonably envisaged. And there's so many aspects of her life for which no restitution can be obtained. But what we would submit is here the courts can ensure compensation for her central loss. And it may pay if I pull up the reference we were talking about before with Lady Justice King in the Court of Appeal at MS 183. Paragraph 104. 104. Where she notes, sorry, I don't need to read it out. Given that, I turn to the fifth heading and the submission within that the assessment of the trust defence, which would bar recovery of a remedy to which Miss X would otherwise be entitled, should be done within a framework consistent with that applied in all other civil cases. And secondly, we say that Patel provides that legal framework, as I've already indicated, whether one considers it to be a pure illegality case or whether one adopts the trust's untethered public policy defence approach. The first, I think there's 6 points we have in support of those submissions. The first point is that Patel applies here because the Supreme Court in Patel expressly said it applies in tort cases. And as I've already submitted, the core of that decision was to produce harmony. And the fact that this is a tort case makes no difference. And if I could invite the court's attention to...
But the tort cases that it was applying in were torts where an illegality had been committed. That's what Patel and Mirza was all about. So in the Hunger and Allen case, which was a tort case, an illegality was committed. In fact, several illegalities had been committed. Ex hypothesi, in your case, in this case, it is not proposed to commit any criminal offence, illegality. You are saying that's the end of the matter. There is nothing illegal here, so that's it.
Yes, that's our primary submission.
Yes, well, you're going to have to get round rather a lot of other cases where the courts have...
What we would say in respect of that is this, that if one is dealing with a bar that is put in place in respect of those who have acted illegally, and that is the approach of the law, that the test in another civil case should be at least as the same, we would submit actually more benign than applied to those who are proposing to act illegally. Now, one can see that there are other cases, tort cases, where there is a fundamental public policy issue in play. For example, issues to do with restraint of trade, or there is a sentence of the court that's been passed and which should not be transcended. Because of the very debates and uncertainty which we'll come to in terms of Parliament intent, this is not such a case. And secondly, whilst there may be cases in which, and for example, Hall and Hebert, which is referred to here, is a case in which the issue of illegality was to do with the fundamental determination of whether there should be liability. In that case, there was a drunk driver, and the question of illegality was at the heart of the tort. We are actually far closer to a contract case in this situation, I would submit, my lady, in the sense that at the heart of the trust contentions is an assertion that there's a proposed contract here that's wrong, if I put it in general terms. Now, we submit that that's based on a wholly fictional counterfactual, and you've seen the paragraph 6.9 where we set that out in our case. But whilst it's not on fours, this isn't a contractual claim, it is probably as close as one can get in the tort setting to such an issue. Because it's really one is...
So are you saying that we ought to be imagining this case as if Ms. X had been a private patient?
Sorry, my lady.
Are you saying that we should examine this case, consider this case, as if Ms. X had been a private patient? Because that's what would... This is a claim against a hospital for negligence.
Yes.
What would be the result if it was a claim against a hospital where it wasn't an NHS hospital, there had been a contract? It was a...
We'd say there's no difference. Sorry, the point I'm making in terms of the contract point is a different one, my lady. I'm not saying there's any contract involved here.
No, of course there isn't any contract. Yeah. I'm trying to understand why you say we should look upon it as a contract case. It isn't a contract case, it's a tort case.
No. What I'm submitting is that in the context of looking at Patel and looking at consistency within the jurisprudence, what Patel was looking at was how it was whether a trio of consideration should be applied, i.e. looking at the purpose of the prohibition. And we say that should apply equally in this context, along with the other countervailing measures. That's the core of it. What one sees within Patel itself is that tort, we would say, is not somehow peripheral to the determination. And if I could invite the court's attention within Patel to MS 312. It was looking at the law, doctrine of illegality as a defence to a civil claim, as the first passage at 99. And then in relation, in paragraph 100, reference is made to Hall and Hebert, which is a tort decision. And that is actually, as I say, is folded in to the heart of these determinations, because it's from that principle, you'll see at the bottom, 101, that's a valuable insight with which I agree. And it is those tort cases, together with the contractual cases, that led to this consideration of the approach that should be taken in this context. And returning again to MS 317, paragraph 120, that feeds into this consideration of the rationale of the illegality doctrine is that it would be contrary to the public interest to enforce a claim. If to do so would be harmful to the integrity of the legal system, or possibly certain aspects of public morality. So one has a situation where the case laws prior to this were dealing with illegality, tainted with illegality. In the past, there were cases to do with the use of, I think it was, carriages in respect of prostitution, that there are, within this determination, it is of relevance to the question of a tortious conduct. And we would submit that there shouldn't be a different threshold being applied. Why we say that this is an legality or illegality case is that the trust is relying on...
Excuse me for one moment. There's a lady at the back who's standing up and is very distracting to our concentration. So could you please go and sit down? Thank you very much indeed. And try and stay off your mobile phone. Thank you. Sorry for the interruption.
At the heart of the trust submissions, they're looking at the Surrogacy Arrangements Act. They're looking at the criminal law. They're looking at legality, illegality, as being at the heart of the argument and why the defence should apply. And it's for that reason that we submit that Patel is material. And similarly, as you've seen from the passages cited from Bridie itself, that what was at heart there within, if I take to two passages, MS 271, in my Lady Hill judgment, in the last sentence, I've no difficulty in agreeing with the judge that proposals put to or contrary to the public policy of the country clearly established in legislation, and it would be quite unreasonable to expect a defendant to fund it. And similarly, you've seen the earlier passages were referred to from Lord Justice Judge, where he focused on the unlawful arrangement. And we would submit that what Patel gives, that otherwise you've not been given, is a principled framework for the assessment. Because we would submit that there shouldn't be an absolute bar, and that it would not be appropriate to impose an absolute bar within the modern jurisprudence.
Speaking for myself, I find it extremely difficult to locate the legal structure within which to analyze this important appeal. But at the very basic level, the damages have got to be reasonable. And so the question arises, because in this country, Parliament has decided not to allow commercial surrogacy, is that something that can be fed into the overall reasonableness of this particular part of your award?
What we would accept that in looking at the defence, we agree that within that first stage, it's important to look at the purpose of the prohibition. And we submit that the purpose of the prohibition is to address and to avoid not-for-profit surrogacy in the UK. But it is not the purpose of that prohibition to extend to California. And it's really within that maybe if I develop our reasoning in respect of those policies, because looking at the trio of considerations, the first is involves, sorry, if I could pull up MS 318. And it's just from my Lord Kerr, paragraph 124. And it's just to note that passage in the second says, and looking at that first heading, A, that such reasons should be subject to by this I understand Lord Toulson to mean the reasons that a claimant's conduct should operate to bar him or her from a remedy which would otherwise be available. That such reasons should be subject to scrutiny is surely unexceptionable, whether in order to preserve the integrity of the legal system, and there citing the tort case of Hall and Hebert, or to allow a proper understanding of the true nature of the public policy imperative for recognising a defence of illegality. The purpose of the denial of a remedy to which the claimant would otherwise be entitled should be clearly understood. And it's in that respect, both in terms of looking at the purpose, one needs to look at the purpose both if it is pure illegality or if it is dealing with a public policy. And
Well, is your primary submission that the answer to this appeal is to focus on the question of criminality first, and that public policy should be left out of that consideration?
yes, because ultimately, we would say that public policy is not against us, but on the trust submission, alternatively, they say public policy was elusive. And we would say that, therefore, if it's not illegality, you can't ground it on an elusive public policy.
Well, then the House of Lords decision in McFarlane and Tayside was wrong, was it?
Well, within McFarlane, my understanding...
You may be coming on to McFarlane later on, because obviously it's a very strong case that points contrary to what you have just said to my lord. But, so if you want to deal with it later, that's fine. If you want to deal with it now, we took Lord Fawkes out of his course lots of times. So.
Well, it's just so that I can understand the steps in your argument. As I've understood it so far, and I may have got this wrong, the primary submission is this is a matter not to be decided by recourse to notions of public policy. I think the second stage of your argument is if you have to have recourse to notions of public policy, the arguments don't all point the same way. There are plenty of public policy arguments, you would say, if I've understood you correctly, which point in the direction, a diametrically opposite direction from that which Lord Fawkes sought to lead us.
Yes, we would say that in respect of public policy, firstly, that one has to focus on UK public policy, not international. Secondly, that it needs to be public policy at the time of the assessment that's undertaken. Thirdly, it must be a clear public policy that's being transgressed. So, and it needs to be clear to justify a judge acting to bar any otherwise compensatable loss.
There are plenty of examples, I think, of judges, even in the highest court, pronouncing on what public policy was, only for completely different conclusions to be reached by...
Very true.
I'm thinking with some smartness about McMichael and the Chief Constable of South Wales or something like that, were great declamations as to what the public policy had been made in relation, for instance, to the liability of police officers for admitted negligence. And a generation or two later, quite different pronouncements were made. And there's a good deal of academic commentary on the question of whether this is something that courts should be doing, certainly without any empirical evidence to support the claims that are made for the public policy considerations. But that's probably irrelevant to your argument.
Well, that is why we say it shouldn't be untethered public policy defence here, because it needs to be tied to the legislation. It needs to be tied to both what Parliament has legislated for, and secondly, what the operation of those rules have meant in practice. And thirdly, as I've said before, that the judge must assess the case in the real world. If I return to the position, just to deal with, to finish with the applicability of Patel. We would submit, just to finish on that, that an absolute bar is not appropriate, and she should not be placed in a position where, as set out within the examples within Patel, in a worse position than them, those who have transgressed the law. If I turn then to the underlying purpose behind the prohibition, I think it is agreed that Miss X's proposed actions are not tainted by any illegality, and there isn't any prohibition which is actually being transgressed. We would submit the Court of Appeal's decision here was not promoting, endorsing, or permitting for-profit surrogacy in the UK. That bar will remain firmly in place regardless of this court's determination. Similarly, the Californian for-profit system exists, and it's used there in a country which has a regulatory and legal regime in place to manage those for-profit surrogacies. And there isn't, we would submit, a clear public policy being transgressed by Miss X's personal reproductive choice here.
It might be said against you that the considerations which led Parliament to prohibit, to criminalise in this country what the sort of arrangement that Miss X is asking the court to support aren't confined to the UK, but they're considerations to do with human dignity, the protection of children and so forth, which are of wider applicability, although Parliament obviously doesn't legislate for the criminal law of other countries.
Our response to that is to, as I said, to look at three areas. And if I turn to the submissions in respect of that, the first is looking at Parliament and asking what is Parliament permitted, what is Parliament prohibited, and as importantly, what haven't they prohibited? If one looks at the start of the process here, the start of what could end up as a overseas surrogacy, Parliament could have banned or rendered more difficult the export of gametes, the export of eggs, to a Californian clinic. They chose not to do that. Instead, Parliament has permitted the transport of gametes from respectable clinics here to respectable clinics in California.
You could give us chapter and verse for that.
If one looks at MS 229, this is the general directions on the export of gametes and embryos outside of the European Economic Area. And within this, sets out the ability to provide gametes to a country such as California.
What's the source of all of this?
This was passed pursuant to Section 24 of the Human Fertilisation and Embryology Act.
Yes.
Which maybe we should provide a copy of. Oh, is it in there? Sorry.
It's under the Human Fertilisation and Embryology Act. Yes.
At MS 227.
There are conditions here on 229 that seem to be consistent with the general approach in our legislation.
Are you looking at F?
Well, F, yes, and also H.
In relation to,
If they could not lawfully be used in licensed treatment services in the UK, in the manner or circumstances in which it's proposed that gametes or embryos could be used by the receiving centre.
So the arrangements in California, for example, if it were to be in California, would have to reflect what is lawful in the UK. So in other words, not commercial arrangements.
I need to obtain general direction one, but the position with that is that the restriction on payment would relate to the provision of the eggs. So that it's tied to the gametes. It's not tied to.
Yeah,
what
but H
happens
is
with the
about
dead.
their use.
And that doesn't impose a restriction, because they would be gametes that could be used lawfully in a
Manner or
licensed
circumstances. Manner or circumstances, that sounds as if it could encompass commercial arrangements.
It's indicating that it's looking at the focus on the eggs themselves, not on what happens.
No, it's talking about use.
Yeah.
I'm sorry, it's absolutely standard that there are controls upon the actual objects, if one can call them that. It's a bit subjects, perhaps, but also upon their use and the manner and circumstances of their use.
I mean, frankly, it would be very surprising. I mean, the authority would be breaking Section 1, wouldn't it, if it were if it were involved in commercial arrangements by exporting gametes for use in those arrangements.
No, because
Unless perhaps it did it gratuitously.
No, because the transfer, it's focused on the gametes themselves, not on the arrangement in respect of.
I'm sorry, it talks about use. Well, you may have to give this a bit more thought.
Yeah, I'll give that.
Actually, so might Lord Fawkes. But that's why I asked.
The language certainly seems to support my lady's point, but it would be quite surprising because, in effect, it would be a major inhibition of surrogacy abroad.
Yes.
If not,
it would mean they'd not be able to use it. My understanding is that the rules are applied to harvesting of the eggs themselves. It doesn't tie to the.
well, as my lady says, I think further reflection on this issue is clearly called for.
The second point is that Parliament hasn't chosen to ban overseas surrogacies. There isn't an intention to prohibit acts outside the UK. And what was the situation is that within the Act itself, it's accepted that normally Parliament wouldn't legislate extraterritorially. But the provisions of the HFEA, there are provisions within the HFEA which do apply extraterritorially, in particular Section 27, and that's referred to in the re-X and Y case, which my learned friend referred to, which is MS 370. So paragraph 5 addresses section 27 of the Act and subsection 3, that the Act, subsection 1 above applies whether.
Sorry, where are you reading now?
Sorry, MS 370, paragraph 5.
Well, that's referring to our rule that the carrying mother is the mother.
Yes. And that was determined and as set out MS 374, paragraph 16G, that applies extraterritorially. So the point we make there is that in this context, when Parliament has had the opportunity to, they have been able to legislate extraterritorially. We would submit that the legislation in respect to parental orders ensured that the most effective bar on such surrogacies was not imposed, namely a rule or even a presumption that they would not be recognised by the UK family courts. Parliament, in fact, took a route which ensured a regime in which the wishes of intended parents and surrogates using the Californian regime would be respected by the grant of Section 54 parental orders. What could have occurred if Parliament wanted to stop such arrangements was to place a bar at the border. And they chose not to do that, undertake that. If I can invite your attention to the case of, at MS 374, similarly, and further on at paragraph 24, on MS 377, at the top of that page at B, if public policy is truly to be upheld, it would need to be enforced at a much earlier stage than the final hearing of a Section 30 application. In relation to adoption, this has been substantially addressed by rules surrounding the bringing of a child into the country. The point of admission to this country is in some ways the final opportunity in reality to prevent the effective implementation of a commercial surrogacy agreement. It is, of course, not for the court to suggest how or even whether action should be taken. I merely feel constrained to point out the problem.
If you're going to refer to the immigration position, you ought to be giving us chapter and verse on that, because my understanding is that it's actually, on occasions, very difficult for surrogate parents to bring the child into the country.
There have been difficulties with bringing children into the country, but our point is that Parliament here, in respect of parental orders, could have responded to this invitation in respect of thereby placing greater barriers to the award of a parental order in respect of surrogacies from overseas. But in fact, they chose to change the test in respect of to be applied to parental orders to welfare paramountcy. And that is addressed within Riel.
There's nothing in the slightest bit surprising about a procedure which is to determine who shall bear legal parental responsibility for a child being governed by the paramount consideration of the child's welfare. It would be surprising if it were any other.
What we would say in relation to that is that in looking at the job that the Queen's Bench Division judge has to do, it's to deal with the position in the real world in terms of the fact that in practice there is awards made for overseas surrogacies. And what one has in this situation is a changed government policy, public policy, that is now positively supportive of surrogacy. As we cite at MS 118.
We've moved off Re-X, I understand that. I was reading down from the paragraph that you drew our attention to, and having inevitably concluded that notwithstanding general public policy, of course there had to be a parental order here, in the paramount interests of the child, the judge did actually go on at 26 and 27 to identify some problems about foreign commercial surrogacies, which other parents might like to bear in mind. Didn't he?
Yes, that's correct.
Very well. I'm sorry, you're going to 118.
118.
Very well.
And this just to note, where we quote it, footnote 25 of 118, that the government supports surrogacy as part of a range of assisted conception options. And so it's not a situation that the Department of Health is neutral on surrogacy. The Department of Health itself is supportive of surrogacy.
But
And-
how does that read in context? Is it supportive of commercial surrogacy? Is it supportive of commercial surrogacy abroad but not in the UK? Obviously, it hasn't changed the law yet relating to the UK. What is its view towards the import of children who have been born as a result of surrogacy arrangements?
Well, what we'd say, if one has that policy in a context where it's accepted there's a shortage of surrogates, that what that means is you have inevitably people are driven overseas in respect of surrogacy arrangements. And if one looks at the Law Commission report, this is within the MS Bundle 480, sorry, 486.
What is this, please?
Sorry, MS 486.
Yes, but what is it?
Oh, sorry, this is within the Law Reform Consultation document,
I see, thank you.
You mean the Law Commission?
Law Commission.
And it seems to be more complete here than it was in the earlier version we were looking at.
Yeah.
So what do you want to draw our attention
And
to?
in paragraph 3.100, the second sentence, data from CAFCAS shows that there's been a significant increase in the proportion of parental order applications where the surrogacy arrangement is an international one. It appears to be the case that international surrogacy arrangements may now account for up to half of parental order applications. And so the point it's making in respect of government, the reality on the ground is that one has a situation where overseas surrogacies are occurring and are occurring in a greater number or number of applications.
Well, we know perfectly well that there are a great many overseas surrogacies. We do know that. We also know that the number of parental order applications is no particular guide to how many surrogacies, even internally, let alone internationally, there are, as not everybody applies for an order. So I'm just a little bit bothered about how much of a guide what is said about parental order applications is to the problem with which we are having to wrestle. And make no mistake, it is a wrestle. You know,
No.
it's not.
The fundamental submission is the same I made before, which is that the Queen's Bench Division judge, in this situation, needing to assess the case in the real world. And within the real world, there is no active prohibition to those who can afford it undertaking Californian surrogacies.
Well, I suppose you might say that from paragraph 3.100, it appears that there's been a significant increase in the proportion of parental order applications, where the surrogacy arrangement was an international one. And as my lady undoubtedly is correct in saying, that isn't necessarily a guide to the number of surrogacy arrangements that are being made. But if anything, there must be more than the parental order applications.
Definitely, definitely, yeah.
So that your point would be that, as you put it, in the real world, which we must strive to inhabit, the number of international surrogacy arrangements must be, how should I put it, significant.
Yes.
Yeah.
And the context and assessing the purpose here of, and the comments that were made in respect of California, I was making the point earlier about looking at the specifics of this case, and there are various authorities referred to, but Miss X is not looking to exploit anyone. And the key points that were in favour of her use of Californian surrogacy, which the court may consider relevant to the evaluation of purpose here, were firstly the control and autonomy. It was that the Californian process would give Miss X control of her genetic material. And we would stress that the reason that she's in the position she's in should not be ignored. It's not what nature has thrown her way, or it's not her gender. It's because of the negligence of the tortfeasor. And because of that, she has been left with a very limited supply of her own eggs, and has only a precious chance to use them, and reasonably wishes to maximize the prospects of success by going to California. Because within the Californian system, one has pre-birth orders, and there's a guarantee that the baby will be hers. She would also have personal autonomy, control over the pregnancy, and she would have a choice of surrogate. Secondly, the US has better data. And thirdly, it's accepted that the UK system is in need of reform, that it can be a harrowing process. And that's of particular importance when Miss X, who's psychologically vulnerable, and in California, should be looking at a process which would take 2 to 6 months, which clearly for someone of her age, 36, is of importance. Whereas in the UK, as I already know, there's a shortage of surrogates, and she's got no family member here who can assist. It is agreed, and the facts find here that California had a well-established system. And probably in response to the points made earlier, if I could invite attention to the Law Commission in respect of how children do within that system, and look at MS 480, paragraph 2.31. And there's a recent study cited noting the turning over onto MS 481, the success, how well surrogate-born children have done, noting 2 studies. And the second, the findings correlate with a recent study of 68 surrogate-born children with gay fathers in the USA. The study found that the children with gay fathers by surrogacy are functioning as well or better than children in the general population. In the first of these studies, the fathers used commercial surrogacy arrangements. It is probable that this was also the case for fathers who were subject of the second study. And so the outcomes...
Isn't that more about gay parenthood, especially male gay parenthood, than it is about surrogacy? Because, of course, adoption apart, that's the only option available to them.
Well,
Isn't that more what that's about?
There's two studies cited
Yes,
there.
but similarly.
And it's really to deal with the point in respect of looking at the ultimate outcome, and that the ultimate outcome through surrogacy arrangements in California on these studies has been good. And the point in respect of California is that in some ways, some, and there's a debate, and this really goes back to the point we're discussing before, that in some ways California has could be seen at the moment of having a better, more ethical approach in the sense that it bakes in control from before conception. We have an agreement that's lodged with the court, and there's clear protections in place. Whereas in the UK, there's currently no regulation. There are no protections in place before conception or prior to birth. The first the court system is aware is when a parental order is applied.
Yes, absolutely. Where do we have a description of the Californian pre-conception arrangements?
The best source of that would be within, or at least a short passage within at MS 1345, and that presumably is within, I think, Appendix Part 2. And then I'll go to the Californian Code. So this is from within the evidence given by Louisa Gavert at trial. And paragraph 5.2 starts on 1344, but turning over the page.
Sorry, you'll have to
Sorry.
help us with the page numbers again.
MS 1.
No, we don't have the MS page numbers.
1345. Yes.
What is this document?
It's Louise Gavert's witness statement. Sorry, I don't know what.
Is this the bundle that has been provided electronically,
Appendix Part
but
2.
not in paper?
No, this was filed at the
Appendix
start of
Part
the
2.
process.
We've got it in paper without the MS numbers.
Internal.
We have internal number. Which one?
It's tab 7.
No, no,
42, I'm being told.
42, yeah. That's the beginning of Ms. Givert's statement, yeah.
And I should note that also she gave evidence at trial and was questioned there. But
Which paragraph will you
so it's
look at?
paragraph 5.2.
5.2.
Well, the final sentence is of interest. It'd be nice to know more about that. It also offers various further safeguards by means of independent legal checks and legal advice for surrogate mothers, counselling and psychological assessment,
Yes, and,
unlike, she says, the Ukraine or Georgia.
and within, sorry, if the court have seen that, within our papers, we've also got the Californian Code, which is at MS 773. I hope that's an MS number that works. I've got that in Authorities Bundle, Volume 2.
Sorry, what's the MS number again, please?
Yes?
773.
773.
Chapter 7613 of the California Family Code.
Yes. And you can, if I just note certain aspects of that, which can be found, I have it on 774, where there's provision made for, on paragraph 4, intended parents cover medical expenses. So paragraph 4 deals with the healthcare process. And within B, prior to executing the written assisted reproduction agreement for gestational carriers, a surrogate and the intended parent or intended parents shall be represented by separate independent licensed attorneys of their choosing. And then at E, an action to establish is there, and just halfway down, you'll see a copy of the assisted reproduction agreement for gestational carriers shall be lodged in the court action filed for this purpose. So there are baked in protections within the code. And another way I think I can illustrate this is by referring to the Law Commission consultation document summary leaflet, if I'm naming that correctly, and in particular the proposed pathway that they are suggesting for the UK, which I have at MS 464. 464. Building Families Who Serve Brazilian Law, Summary of Consultation Paper, and that starts at 455. And I should know that within it there are a number of helpful diagrams, but what's of interest for this in terms of the comparison, so this is what the Law Commission is suggesting for the future in the UK, none of which currently exists. As well, ladies, well, it is, I think, the language within the Law Commission Board. It's a done deal in the UK by the time the Family Division judge has to rule on a parental order.
Well, that is not a complete picture, because if it's done in a licensed clinic in the UK, which if it's IVF is essential, obviously if it's donor insemination, it isn't, well then all the requirements of the Human Fertilisation and Embryology Act and Code have to be complied with,
Yes, so the
which fits all of this. So the only thing that this is adding is the pre-surrender of parental status in relation to the child, at least if it's done through the Human Fertilisation and Embryology Act licensed system. It won't always be, as I've said, but if it involves IVF, it definitely will be.
The contrast is with the proposal across the board for the United Kingdom is very similar to what's already in place in California, was really the point I was wishing to make in response to...
Yes, and I was simply seeking to augment the very limited picture you'd given of what there is in the UK. You'll have to forgive me. I was a founder member of the Human Fertilisation and Embryology Authority. I lived through and fought through many battles on just this sort of issue. And so it's still very alive in my mind, although I appreciate that the law has changed since then to some extent, but the basic principles remain the same.
I'm afraid I'm a novice in this area by comparison, but I'd like to understand better how you actually get the child into the UK. The child is born in California. In the eyes of our law, it's not related to the commissioning parents. It's not a British citizen.
Yes.
So one can just imagine the problems bringing the child into the UK.
There is a helpful passage, I know, within the Law Commission that deals with this, which I'm not immediately...
Well, I've looked for it, and I know where it is, but it's not been reproduced in the hard copies. I'm assuming I don't know, but I rather assume you have to get the parental order in order to have legal relationships sorted out before you bring the child back?
No.
No.
Sorry, I defer.
But you're bringing back an American child that's not related to you. You have to get a visa, I suppose, to bring the child in.
That was why I was asking about the immigration situation.
Yes.
Yes, and within...
I'm just wondering how much the judge awarding damages has to assume is going to happen, if this is going to be a reasonable award.
Well, sorry, in terms of that question, that's clearly something that prospectively can be addressed and assessed within the trial process. And it was addressed in terms of the complexity of it within Ms. Gervert's statement, where I think maybe the same page as we were before, which may cause the same problem. It's MS 1345.
What's internal, page 49, is it? That's where we were before.
Is that?
Surrogacy in the US.
Yes. And it's the passages that deal with it are 5.3, 5.4, 5.5.
Well, complex international law issues.
And there also are some Law Commission reference, which I'll pull out overnight, because...
Mr. Johnston, I wonder whether the best way of handling these difficult questions from my colleagues is to say the judge clearly went into this to some extent. The hospital had the fullest opportunity to make points about the difficulties of commercial surrogacy in various respects, including immigration, insofar as it didn't. And I, Mr. Johnston, have on my side a clear finding in paragraph 31 of Sir Robert's judgment, which we've got, of course, at 199. If you've got that to hand. Third line. The advantages over the UK, where commercial surrogate arrangements are illegal, are clear. The system is well established, the arrangement binding, the intended parents can obtain a pre-birth order from a Californian court. So shouldn't you be respectfully inviting us to take that as a finding of fact, and whatever our private concerns, not to go delving too deeply into matters of evidence which aren't really for this court?
Yes, but I agree, my lord. And I think what I was aiming to do in showing the pathway and so forth was to respond to some of the points that have been made about California, but I return, I think it was my first introductory point, which is to say the case needs to be decided in the evidence in this case, and in terms of the projection for the future, which the judge had to undertake.
But with the greatest of respect, Mr. Johnson, the immigration status of a child born abroad to, as a result of an arrangement, whether it's commercial or uncommercial, is a matter of immigration law. It's not a matter of fact, it's a matter of immigration law.
But I think in terms of the ultimate determination that the judge was making here, he was having to assess in the future whether there would be a surrogacy arrangement and a child that would be brought back to the UK. And there's no evidence adduced from the defendant to say that that would not happen here, that there would, for Miss X or her partner, be some insuperable immigration problem that would arise that would prevent her bringing these children home.
Well, paragraph 5.3 makes the position, the uncertainty of the position clear.
And I'm not arguing that the immigration status, and it's a point that's of concern within the Law Commission, because the Law Commission are proposing that for certain countries with well-regulated systems, that the Secretary of State should approve them, and that therefore there might be some improvement in that area. But I think in terms of the ultimate determination of the Queen's Bench Division judge, the answer I give is the same, which is there isn't a basis here for saying he was wrong in concluding that this would happen. All the evidence that was received and conclusions he would reach support the determination that that's what would probably happen with Miss X.
Louisa Gervert was your witness, wasn't she?
That's correct.
And she's saying there are all these problems about getting the child back to the UK.
Yes.
The judge doesn't disbelieve her evidence, does he?
Doesn't refer to it.
Doesn't refer to it, no. He doesn't, in the end, he doesn't need to.
Well, clearly the indication is that she's correctly identified that there are problems with this, that advice is needed and support given. But that ultimate, sorry.
Sorry, I just would find it difficult to take the sort of course which being suggests that we should also assume the judge has decided that all those problems can be dispensed with, simply on the basis of what he says in paragraph 31.
What he's doing in a damages assessment is making his best assessment of what would happen in the future. And the ultimate balance probabilities determination that he reached was that this is going to be reasonable expenditure because the surrogacy arrangements can be achieved in California, and that the children would presumably be able to be brought back to the UK. But that's not to say, and I'm not gainsaying, that there aren't complications with the immigration system that are in place. Looking at the Law Commission report itself, it's a consultative report, as has already been intended. It's not a final report. But the Commission's discussion and analysis of the law and practice doesn't gainsay that what we've just been discussing in terms of the evidence which was received about the systems in XX. And in terms of the policy approach, the focus of the Trust submission about the future landscape or what's been going on since 2001 is that it indicates that there isn't going to be a halt placed on surrogacy in this country, or that there will be a bar placed on surrogacy arrangements in the future, or a bar placed on overseas arrangements in the future. As I've already indicated, they support a system which paves the way for recognition of foreign regimes, well-established regimes, of which it would appear California may be one. I was just looking to, well, sorry, I was going to just deal with just a reference to deal with a completely separate point that in respect of the public policy, but maybe I should leave that till...
Well, if it's a separate point, it might be easier for you, unless you can complete it in 2 minutes, which...
No barrister probably ever has.
Well, sometimes it can happen, yes. Anyway, we're doing quite well for time, I think. How much longer do you anticipate needing tomorrow?
I want to reflect on the McFarlane matter, but
yes.
Within that, I don't see I'd need longer, as long as I was in maybe 30 minutes, 45 minutes.
We're not wishing to rush anybody, but it's useful to us to have some indication.
Well, maybe if I say 45 minutes.
Thank you very much indeed. Well, we'll adjourn now and look forward to hearing from you at 10:30 tomorrow morning.
Thank you.